All rise. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. In case the people versus Sean William Brisboy. Counsel identify for the record, please.
Good morning, Your Honor. Mark Quinn on behalf of the people.
Please, the court, Scott Moore for the defense.
You are Sean William Brisboy.
Yes, Your Honor.
Previously, you appeared in court and pled to the charge of controlled substance, possession of a narcotic less than 25 grams, plus habitual criminal offender third, making that a felony with a maximum penalty of 8 years in prison. Minimum is discretionary with the court. A pre-sentence investigation report has been prepared. Sentencing guidelines are 2 to 25 months. Mr. Moore, have you had an opportunity to review that pre-sentence investigation report with your client?
Yes, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert?
No, Your Honor.
Any objection to the scoring of the guidelines?
No, Your Honor.
Mr. Webb, on behalf of the people.
Thank you, Your Honor. Reviewed reports have no additions or corrections to make to them, and I believe the guidelines are correctly scored.
Mr. Brisboy, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
Mr. Moore, on behalf of your client.
Thank you, Your Honor. We believe that the agent who prepared the report is fully seized with the facts in this case, and we would support the recommendations be adopted and the plea agreement go forward with 7411 status. Thank you.
Mr. Webb, on behalf of the people.
Your Honor, given the facts and circumstances surrounding this particular case, without considering his prior criminal history, I believe the plea agreement is appropriate, and the recommendations by the probation department are also.
The court has reviewed to the pre-sentence investigation report does provide for sentencing guidelines of 2 to 25 months. In order to punish you for what you have done to attempt to rehabilitate you, deter others from committing similar acts, it can be a sentence of this court that you be placed on probation under 7411 status for a period of 18 months. Along with the statutory terms of probation, you have the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with one you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must attend AA, NA, or CA meetings at the frequency required by the field agent. You must complete an outpatient or residential substance abuse treatment when referred by the field agent. You must complete mental health or other recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose it to the field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not use any object as a weapon. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate conditions of probation. You must reside in an approved residence and not change your residence unless you first obtain written permission from the field agent. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week, unless engaged in an alternative program approved by the field agent. You must pay a $68 state cost, a crime victim's assessment of $130, $30 supervision fee. If the Department of Corrections decides to put you on electronic monitoring, it'll be $60 a month. Court costs of $500, a fine of $500. How much are you charging for attorney fees, Mr. Moore?
$250, Your Honor.
$250 for court-appointed attorney fees. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. Must not use, purchase, or otherwise possess recreational marijuana or be in the home of any or company of anyone who uses or possesses recreational marijuana. Must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from your field agent. Must set up an installment payment agreement with the Clare County Clerk's Office within 30 days. And the court's gonna also order you to do 40 hours of community service. If you do everything you're told, good things happen. You won't have another felony on your record. If you fail to do everything, you're gonna come back in front of this court for something. So please see the probation officer before you leave here today. On the case versus Crystal Lee Hovinga.
Chief Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
We have to court Scott for the defense.
You are Crystal Lee Hovinga?
Yes, sir.
Alright. This is just set as a status conference.
Thank you, Your Honor. My client has matters pending at the Bay County Circuit Court as well as the 80th District Court that have yet to be resolved. She has posted bond. We ask the court to continue bond and reschedule this for a status conference perhaps. Given the number of cases that we have to clear up, I'm going to ask for 30 days.
Any objection from the prosecution?
None, Your Honor.
We'll set this for another status conference in 30 days. We've already held the pretrial on this, is that correct?
Yes, sir.
All right. And I think what we'll do is we'll put this on the trial docket if it doesn't appear to be set for a trial date and a final pretrial date.
Thank you.
You're all set, Ms. Ovinia.
Do you want to call the cases?
Calling the cases of people versus Kyle Thomas Ackerman.
Morning, Your Honor. Mark Webb on behalf of the people.
May it please the court, Scott Moore for the defense.
Mr. Ackerman is not present or available by Zoom. We'll set as a status conference. Do you have any contact lately with Mr. Ackerman?
Your Honor, I can resist any sort of torture or coercion unless the court asks me a direct question.
Okay.
As it happens, yes, Mr. Ackerman, or at least someone using a telephone number attached to Mr. Ackerman, sent me a text Friday last week indicating that he received our reminder of the status conference. And I'm quoting from the text, "Okay, thanks. I just got out of hospital visiting my dad. He just got out of ICU. He has cancer and he's fighting very hard to stay with us. It's been hard." That was received at 4:13 p.m. on Friday. That is the last contact I've had with Mr. Ackerman.
Anything from the prosecution?
Just ask for benchmark on court, which
All right. Mr. Ackerman's bond will be canceled and fourth benchmark will issue for his arrest bond amount of $150,000 cash in both cases.
Both cases, second time.
75 each.
No, 150 each.
250 total, or
300.
300 total. Those higher maths.
Let's see if those larger numbers. Calling the case of the People versus Scott Elwood Sizemore.
Chief Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Court for the defendants.
And, apparently Mr. Sizemore has not appeared in person or via Zoom.
And all candor to the court, Mr. Sizemore has been very good about staying in touch with my office and appearing for court hearings. Here's that we did send a letter to him covering the notice to appear on June 8th, 2001. I did not personally follow up with him. We might have sent him a text, but I don't have that right in front of me. Given the nature of the case and the prior history of cooperation with my office, at least, I would ask the court to consider scheduling this for a show cause.
Anything from the prosecution?
Senator, I would leave that within the discretion of the court. I do know that we have a trial coming up fairly quickly. So I would ask that that be set relatively quickly so we can resolve any issues as it relates to the pending jury trials in both of his cases.
Court's going to cancel and forfeit Mr. Sizemore's bond. The last court date, we had a little trouble communicating with him. He was told via Zoom to be here on this court date. He has not appeared. So his bonds will be canceled and forfeited. Bench warrant will issue for his arrest. Bond in the amount of $100,000 in each case. Cash. So that's the trial date goes. Leave this on the trial docket for another week or so,
Yes, sir.
in case he shows up.
Yes, sir.
All right. Well, court won't issue a bench warrant for at least 2 days. Court will keep this on the trial docket. If he has not appeared in court before then, by next week, by next Monday, then the trial date will be adjourned.
Understood, Your Honor. Thank you.
All right. Calling the case of the People versus Joseph Russell Ware.
May I approach Your Honor with the prosecutor?
You may.
I don't know if this is my case. Is this your case,
I
Alicia?
just need a prosecutor.
Oh, okay. Never mind.
Just one moment.
This is a impediment case. This is Gerald White's. All right. And the question is do you want to appear on Mr. White's cases or?
At this point, I'll stand in for him.
Your Honor,
Yes.
I did have communications about 10 minutes ago with Mr. White, and he asked that I request that the court adjourn today's hearings on Joseph Ware and the case that he is appointed on for Mr. Mixner due to the fact of some family emergencies that have come up, and I have no objection to that. My understanding is that he is going to be forwarding written stipulations for adjournment that I will sign when I receive them. So I did want to let the court know that information, but I don't have any objection to if Mr. Moore wants to jump in.
The court will adjourn Mr. Ware's and Mr. Mixner's cases. Those are on, we're set for people's motions to revoke bonds. If you're stipulating to the adjournment, the court will go along with that and leave it up to the prosecutor to reset those for hearing.
Thank you.
Did you?
Mr. Rexter is the only other one from here.
Then, any information on Mr. Rexford's case? Did he talk to you about that one?
He did, yes, Your Honor. And in that particular case, that he spoke with Mr. Rexford, and Mr. Rexford wants to continue towards trial. He did indicate that he's going to, meaning Mr. White will be filing a motion to withdraw from this case due to the extenuating circumstances that he is in at this time.
All right.
Your Honor, for the record, Scott Moore, I did have a communication or rather a telephone call with Karen Moore, the contract administrator for the MIDC. It is my understanding that I may be assuming all or part of Mr. White's docket, either on an interim or a permanent basis. Nothing has been filed. I have very little information except I am stating for the court that everything the prosecutor said is correct. And my information supports that as well. We hope to have this straightened out by the end of business tonight.
All right. Mr. Rexford's case is scheduled for trial on July 21st. There will be a new attorney coming on. If he's applying a motion to withdraw, we will adjourn that trial date. We will set a status conference for the first motion day in August, and we'll proceed from there.
Thank you, Your Honor.
Thank you.
Thank you, Mr. Moore.
Thank you, John.
We're in recess.
All right. All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
May be seated. In the case of People versus Joshua Michael Hoffman, you are Joshua Michael Hoffman.
You unmute your microphone, sir.
There we go. There we go. Yes, sir.
All right. And you're here on a bench warrant issued for failure to appear to a show cause hearing.
Yes, sir.
Appears you owe some money. You haven't made payments on the fines and costs in this matter.
Yes,
Are you
sir.
currently on parole?
Excuse me?
Are you currently on parole?
Yes, sir. Yes, sir. I got paid. Got paid them money as well.
All right. And you have a permanent home?
No. No, I'm off parole. Yeah. The hell with that. I'm off parole next year is what they said at the end in January, I believe. But y'all should know more right there.
Yeah. Where are you staying?
I'm staying 720, I think what it was. 7026 Partridge Avenue.
All right. Then who lives there?
It would be me and my girlfriend,
All right. What's your girlfriend's name?
Morgan Flynn.
All right. And are you currently employed?
No, sir, but I can get a job up Pollington's though, right there in Marion. I believe I can. I tried to have a job there and I ended up messing it up. I had, man, a whole lot of bad luck, I guess, and bad choices as well.
When's our next show cause date?
It's August. It's in August.
And then do we have one for October then after that? All right. Do we know which day it is in October?
I
All right. All right, Mr. Hoffman, what I'm going to do is I'm going to cancel this show cause. All right.
Yes, sir.
I want you to, once you get out, start making payments on these cases that you owe money.
Yes, sir.
And I'm going to set a court date in October for you to appear. If you have made at least 2 payments before that October date, then you probably won't need to appear as long as you're in contact with the clerk's office and making payments. we're gonna be fine, but if you haven't made a payment, you better show up,
Yes, sir.
all right?
Yes, sir. I will. And, so do I get to go now from here?
Well, we're gonna release you on this. If you have a parole hold or anything on you, then, and I think you have another case that's gotta be attended to, so I don't know. All right, but as far as I'm concerned, you're okay to go.
Okay, thank you.
We're in
And we're
recess.
good. We're good.
Unless the warrant's not in lien. That says he's got a parole absconder warrant.
Well, so then move on from that.
Well, I don't know. Unless it's not, I'm gonna send, the agent just a heads up.
We won't take our temp over right away.
Well, that's all right, we won't do that, and I wanna get the October date.
The
to be
date
able
is-
to hand it to him before
Does-
he.
I don't know what it is.
Does he have a show cause warrant on the other case too?
No.
Oh, just this one then?
With Judge Meek's last show cause, it was the I did over 120 people, so we could just start fresh. But I can't do that with Judge Evans.
Right.
I already put water in there. He said that it was.
Yeah, I did.
Yeah, that's.
Makes things at 10. Rock and roll.
We did a lot.
Yeah, I'm tired. Before we have-
No,
No, this was the only case for this, but then I do believe Eric said that it's parole absconder, so they might have a little bit of that stuff. So you were right to say that you may not get out of jail. I don't know, that's a good answer, I don't know. We'll see. Never give definitives.
what are we doing on Hovinga's bond?
All right, huh?
What are we doing on Hovinga's bond?
District Court is now in session, the Honorable Roy G. Meek presiding.
May be seated. In the case of the people versus Xander D. Menther, counsel identify for the record. Mr. Menther, come up to this podium.
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Karen Township appearing on behalf of Mr. Menthner.
You are Xander Dean Menther.
Yes, sir.
This is set as an arraignment, Ms. Township. How do you wish to proceed?
Your Honor, my client intends to accept the offer. I just want to make sure that we have, I believe we have the appropriate felony information for him to proceed. I don't know if the court has gotten any type of offers yet.
No, the court hasn't received any pretrial summary or anything. I don't know, is there an offer from the district court in there is that the same?
That is what I'm looking for, Your Honor.
Probable cause conference, says as charged, agreement with HIDA status, no initial incarceration.
Correct, Your Honor.
All right. How old are you, Mr. Mentor?
18.
You raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Take your hands out of your pockets.
Yes.
And you received a copy of the information or gone over that with Ms. Tomczyk, is that correct?
Yes.
And for today's purposes, is he waiving reading of the information and preliminary examination?
Yes, Your Honor.
We're being charged with count one, breaking and entering a building with intent. That is a felony. It carries a maximum penalty of 10 years in prison. The minimum is discretionary with the court. They're also being charged with larceny in a building, a felony that carries a maximum penalty of 4 years in prison and or a $5,000 fine. Minimum is discretionary with the court on both cases. You'll also be charged costs and other fees regarding this. You understand that?
Yes, sir.
There's one of three possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of three possible pleas you may make?
Yes.
Answering the count one, breaking and entering a building with intent, how do you plead?
Guilty. Guilty.
Guilty?
Yep.
All right. Answering the count two, larceny in a building, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes.
The court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
All right, that's an advice of rights form that covers everything I just said. Please sign it and date it.
This is the wrong address on this.
Incorrect address?
Yes, ma'am.
All right.
9224 East Coleman Road, Coleman, Michigan.
Ms. Schwartz, what is the plea agreement?
Your Honor, the agreement in this case is that the defendant will enter a guilty plea as charged. There is a disclosure agreement of no initial incarceration and HYTA status. Restitution is to be determined to the victim in this case, Andrea Elaine Daly. Other terms of the agreement, there are none.
Ms. Tomczyk, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Mentner, did you hear what was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
I know.
Have you understood everything that the court has told you?
Yes.
In light of everything the court has told you, do you still wish to plead guilty?
Yes, sir.
Did you break and enter a building, a restaurant located at 203 East Main Street on or about May 9th of 2021 in Surrey Township, Clare County, Michigan?
Yes, sir.
And you did that with an intent to commit a larceny therein?
Yes, sir.
Did you actually steal anything or take anything from that property?
No, sir.
And on that date, did you actually steal a credit card machine?
I have no memory of that, no, sir.
Ms. Tomczyk, do you wish to ask him any questions?
Yes, Mr. Methner, your lack of memory is due to being intoxicated.
Yes.
Okay, and in breaking, in entering that building, you did break a glass door?
Yeah.
Sorry, I couldn't hear that. Is that a yes?
Yes. Yes.
Okay. And so, even though you may not remember taking the credit card machine, is it a strong possibility that you did?
Yeah, I guess so.
Okay.
Is there anybody else involved in this besides you?
No.
Any questions, Ms. Schwartz?
Your Honor.
Are you satisfied with the factual basis, Ms. Schwartz?
Yes, Your Honor.
Satisfied with the factual basis, Ms. Tomczyk?
Yes, Your Honor.
Has court complied with the court rules, Ms. Schwartz?
Your Honor.
Has court complied with the court rules, Ms. Tomczyk?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence of either the prosecutor, the defendant, or anybody acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandingly, and knowingly made. Plea is accepted in order to enter upon the records of this court. Sentencing will be set for September 27th at 10 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Please see the probation officer before you leave here today. Captain at the jail.
Yes.
On the case of People versus Stephen John Kaplan, counsel identify for the record, please.
Morning, Honor, Mark Webb on behalf of people.
Morning, Your Honor, Karen Tomczyk, on behalf of Mr. Kaplan.
You are Stephen John Kaplan?
He appears to be muted, Your Honor. I don't know. Mr. Kaplan, can you unmute that?
There you go. Yes, sir.
All right. And this is set as an arraignment. How do you wish to proceed today, Ms. Tomczyk?
Waive arraignment, ask the pleas of not guilty be entered, and have this matter set on the trial docket.
All right. Pleas of not guilty will be entered on behalf of Mr. Kaplan. This will be set on the trial docket with the pretrial being scheduled next. You're all set, Mr. Kaplan.
Thanks.
Calling the case, the People versus Vicky Louisa Johnson.
Good morning, Honor, Mark Webb on behalf of people.
Morning, Your Honor, Karen Tomczyk, on behalf of Ms. Johnson.
You are Vicky Louisa Johnson?
Yes, sir.
All right. And this was set for sentencing on a probation violation today. An updated case report provided. Have you received that, Ms. Tomczyk?
I have, Your Honor.
And you've been released from jail, Ms. Johnson? You've been sentenced from Clinton County and released from jail, is that correct?
Correct.
All right. The court wants to do is adjourn this to September 27th to see how Ms. Johnson does while she's out of jail and do sentencing then. Any objection, Ms. Tomczyk?
No objection, Your Honor.
All right, we'll adjourn sentencing till September 27th at 10 a.m. Continue to report as required and start making payments on your fines and costs.
I have started making payments and I did the initial with Meyer Warehouse in Lansing and I'm waiting to get my orientation date.
All right. Just make sure you keep in contact with the probation department. They know what's going on.
Yes, sir.
All right, you're all set for today.
Thank you.
Contact your agent.
She's on her way.
She is, okay. If I can have just a moment, I need to identify a couple. Good morning, could you please unmute your microphone and identify yourself? Telephone number ending in 407, please unmute your microphone and identify yourself for the court.
My name is Bernie Doran. Can you guys hear me?
Yes, I can hear you. What did you say the last name was?
Doran, Dorin.
Okay, Mr. Doran, we have not reached your case yet. I'm going to place you back in the waiting room. Please be patient and we'll be with you shortly, as soon as we can.
Okay, thank you.
You're welcome. Telephone number ending in 615, can you please unmute your microphone and identify yourself to the court? Telephone number ending in 615, please unmute yourself and identify yourself to the court.
Michael Pink.
Okay, Mr. Pink, we have not reached your case yet. I'm gonna go ahead and place you back into the waiting room. We'll be with you shortly, okay?
Okay, sorry.
Nope, that's okay. I'm just gonna place you back in the waiting room. Just hang on tight and we'll be with you shortly.
Okay.
Could you please identify yourself to the court? Telephone number ending in 138, please identify yourself.
Hello.
Yes, could you please identify yourself?
Stanford John Adams.
Okay, Mr. Adams, we have not reached your
Yep.
case yet. I'm gonna place you back in the waiting room and we'll be with you shortly, okay?
Okay.
Okay, just hold on tight. We'll be there short as soon as we can.
All right. Thank you.
Jill hung up. You're gone.
Joey, can you check the device with the circuit appears to have logged off?
Move on from Matthews to the next case. Calling the case of the People versus Summerlee Marie Darabos. Counsel identified for the record.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Karen Tomczyk appearing on behalf of Ms. Darbos. Is she in the Zoom waiting room?
No, she's not appeared. She's not present in the courtroom.
She did contact me just a few minutes ago indicating that she was having some difficulty signing on and asked me to make sure she had the right ID and passcode. So I have given those to her. I'm hopeful that she will sign on. This is a client that I don't have any difficulty contacting.
All right, well, today's just a status conference. Has there been any changes in the status of this case?
No, Your Honor.
There is not, Your Honor.
All right, then we already have a final pretrial set for July 27th. And what the court's going to request is that you and your client appear in person. All right?
Not a problem, Your Honor.
Okay, you're all set. If she calls in, we'll tell her.
Oh, I got it again, Mike.
All right, calling the case of the People versus Allison Lorraine Matthews, counsel identified for the record.
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Thank you, Your Honor. Karen Tomczyk appearing on behalf of Ms. Matthews.
All right, you are Allison Lorraine Matthews. Need to unmute.
Yes, Your Honor.
All right. And there's been a motion filed for evaluation of competency in this case. As I understand it, there's already been filed one in another case in district court. Is that correct, Ms. Tomczyk?
Yes, Your Honor. There's actually in 2 cases that are still in district court. And the orders have already been sent to the forensic center.
And she's already been sent to the forensic center?
There's already been a referral made. I don't know that she has actually been evaluated yet.
All right, the court doesn't see the need to sign an order for this case. So what we'll do is we'll just wait to hear back from the other cases once she has an evaluation. So we'll adjourn sentencing. I think at this point, we'll adjourn it out in about 4 months. The other aspect is she has not completed a PSI packet. And nothing's been done. Any objection for the Department of Corrections to visit her and have a PSI packet done? Or do you wish to be present when that's done, Ms. Tomczyk?
I do wish to be present. No objection to doing it, but I do wish to be present when the interview is conducted. I have no objection in giving her the packet without me there.
All right, then that'll be the order that the department will contact her at the jail, give her the packet to be done, and then schedule the interview with you being present.
Thank you, Your Honor.
All right, so at this point, we'll adjourn this out about 4 months, and hopefully we'll have some results by then. Anything else from either party?
No, thank you, Your Honor.
No, Your Honor.
What is the bond for this charge?
On this one, if you posted it, it's probably still in effect because we haven't canceled it yet. I mean, so I have no idea. Last I see, it was at 7,500, but I don't know if it's been posted. I believe it was because you failed to appear on your pre-sentence investigation and fill out the packet, in which normally we'd be canceling the bond.
It looks like she has a $25,000 cash bond that's currently open.
Anybody want her bond to be canceled so that we know where she is and we can get a hold of her?
I'm actually incarcerated at this time. I've for a total of 77 days since last August. That would be 88 days with good time. I was wondering if I could request to please have that $25,000 cash only bond be at least a surety attached to that. So, I mean, I have a house here in Clare County. I have children that I am trying to get parenting time with. While incarcerated, I'm not able to do that.
Your Honor, I would ask that the bond be forfeited in this particular case, if it hasn't already been done so.
Your Honor, I know that Ms. Matthews is trying to post bond. As she indicated, she does have a child protective case in which she is working with the Department of Health and Human Services. We would ask that you keep the bond in place, and if not, add a surety to that. She does still have 2 bonds out of district court that have yet to be posted.
Your Honor, it's my understanding that DHHS case has been long-standing prior to the defendant's failure to appear in this particular case. So as far as the ability to work that plan now, I would certainly leave that within your discretion of the court to give what weight you choose to do so to that.
The bond is still set at $25,000 cash. The court's going to leave it at that.
Is there a possibility to at least have an surety attached to that, Your Honor? Like I
I
said,
think, Ms. Tomczyk, if you wish to make a motion to reduce bond or amend the bond, then you need to do a written motion on that aspect.
We'll do that, Your
All
Honor.
right? Okay,
is it
you're all
possible?
set, Ms. Matthews, for today. I believe that takes care of all your cases for today.
I believe it does, Your Honor. Thank you.
All right.
Mr. Pink is on the phone.
All right. Calling the case of People versus Michael Stephen Pink. Counsel identified for the record.
Morning, Your Honor. On behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Pink.
And you are Michael Stephen Pink?
Yes, I am.
All right. Mr. Rowe, today was set for an arraignment. How do you wish to proceed?
Your Honor, Mr. Pink waives the reading and he pleads not guilty.
Not guilty pleas will be entered on behalf of Mr. Pink. This will be set on the trial docket with the pretrial being scheduled next. You're all set for today, Mr. Pink. You can hang up.
Okay, thank you.
We have Mr. Chaston in the courtroom. Calling the case of the People versus Stephen Allen Chaston. Counsel identify for the record.
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Your Honor, Austin Rowe, appearing on behalf of Mr. Chaston.
And you are Stephen Allen Chaston?
Yes.
All right. And we have a pretrial summary filed for case number 21-6665-FH. The other case, 19-6180-FH, is a probation violation case. Have you received a copy of the pretrial summary, Mr. Rowe?
I believe I have, Your Honor, yes.
Have you had an opportunity to go over that pretrial summary with your client?
Yes, I have.
And do you wish to take advantage of the offer in the pretrial summary?
Your Honor, I think that we're still in the process of negotiating with the prosecutor. Would ask the court if we could set this out for a status conference, as well as the probation violation hearing too.
And you're waiving the right to have the hearing within 14 days on the probation violation?
Yes, Your Honor.
All right, we'll set a status conference about a month out. Date that would be. Should be August 9th at 10:20 a.m. on both cases. Anything else, Mr. Rowe?
No, Your Honor.
All right. You're all set, Mr. Chaston. All right. Calling the case of the People versus Charles Dale Middleton. Counsel identify for the record, please.
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Middleton.
You are Charles Dale Middleton?
Yes, Your Honor.
All right. And got a case report. Did you receive a copy of the case report?
I
Mr. Rowe?
have, Your Honor, and I discussed that with Mr. Middleton. And Mr. Middleton and I discussed it, in fact, last night. He told me that he intended to go to the probation office and get another copy of that packet that was to be filled out and try to get it filled out before the hearing this morning. And I'd like to ask Mr. Middleton, have you been able to get a copy of that packet?
No, sir. I was up here, every bit of 45 minutes early. I went downstairs and asked Scott Codier for the packet, and, he told me he's not gonna give it to me and wait until I get in front of the judge, sir.
Anything further, Mr. Rowe, on behalf of your client?
Your Honor, I just tried to make note that Mr. Middleton has tried to remedy the situation in which the sentencing report was not able to be completed because of not having that completed packet from Mr. Middleton.
Well. Per the usual process of the court, his bond is gonna be canceled this time. We're gonna take him into custody until such time that the pre-sentence investigation packet can be filled out and that the interview can be done. Once that interview is done, then Mr. Middleton can be released back out on bond. All right, so I want you to go with that officer there.
Any facts on these? We'll take the long one. We'll take that long one.
No, I couldn't. And we'll adjourn this sentencing out approximately 6 weeks. It may get adjourned out to September 27th, I think. Probably be the date.
Would that be at 10:40 a.m., Judge?
What'd you say, Ms. Schwartz?
Would that be at 10:40 a.m. on the 27th?
Yes.
Thank you.
On the case of People versus Stanford John Adams.
Assistant Prosecuting Attorney Elise Schwartz appearing on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Adams.
And you are Stanford John Adams?
Yes.
The case report has been presented to the court. Have you received that, Ms. Schwartz and Mr. Rowe?
Yes, Your Honor.
I have received it, Your Honor.
All right. Any objection to adjourning the sentencing out 2 weeks?
None, Your Honor.
No objections, Your Honor.
All right. We will adjourn this until July 26th at 10:40 a.m. Did you hear that, Mr. Adams?
July 26,
10:40.
10:40, okay?
All right.
Yep.
All right, you're all set, Mr. Adams. You can sign off.
Oh, okay. All right, thanks. Have a good one.
You talk to him, tell him I'm in court right now.
And I think this should be Jacob Penn, correct?
Yes, that should be. While we're waiting for Mr. Hill, Mr. Doran was on the phone. Let's take that case.
Okay, I brought him in.
Calling the case of People versus Bernie Chance Doran. Counsel identified for the record.
Chief Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Doran.
You are Bernie Chance Doran?
Yes, sir.
All right. This was set as a status conference. Was there, did you previously receive a copy of a pretrial summary, Mr. Rowe?
I did, Your Honor, and Mr. Doran and I have discussed it. You'd like to accept the plea bargain on it.
All right. How old are you, Mr. Doran?
Pardon? You broke up a little.
How old are you?
I'm 30 years old.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Doran, have you received a copy of the information or gone over the charges with your attorney, Mr. Rowe?
Yes.
And Mr. Rowe, is he waiving reading of the information for today's purposes?
Your Honor, he is, and I should amend one more thing. He's going to accept the plea bargain according to what was discussed with prosecutor last night, in which added term of 7/4/11 sentencing be added to that.
All right.
That is an
That could be done at the time that we get the plea agreement on the record. It's still as charged, is that correct, Mr. Rowe?
Yes, Your Honor.
All right. And previously he waived preliminary examination, is that correct?
That's correct, Your Honor.
Mr. Doran, you're being charged with controlled substance possession of methamphetamine, a felony that carries a maximum penalty of 10 years in prison and or a $15,000 fine. Unless sentenced to more than 1 year in prison, the court shall impose license sanctions. Otherwise, the minimum is discretionary with the court. Do you understand the charges and the possible penalties?
Yes, sir.
There's one of three possible pleas you may make to this charge. You may plead if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. Do you understand the one of three possible pleas you may make?
Yes.
Answering to count one, controlled substance possession of methamphetamine, how do you plead?
Guilty.
Do you understand that no one may make any promises for this court as to what your sentence will be?
Yes.
The court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
I do.
Understand by pleading guilty, you give up each and every one of those rights.
Yes.
Ms. Schwartz, what is the plea agreement?
The plea agreement is that the defendant will plea as charged with a Briggs-Kilgore agreement, treatment under 7411 status. There's, I believe that concludes the entire agreement. Yes, Your Honor.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Doran, did you hear it was put on the record as the plea agreement?
Yes, I did.
Did you understand it?
Yes, I did.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was placed in the plea agreement to induce you to plead guilty?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Pardon you. You broke up. I'm sorry.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily? And are you doing so freely and voluntarily, Mr. Doran?
Yes. Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, I do.
In light of everything the court has told you, do you still wish to plead guilty?
I do.
Drawing your attention to on or about June 11th of 2021, were you in Hayes Township, Clare County, Michigan?
Yes.
And did you have in your possession some methamphetamine?
Yes.
Did you know it was methamphetamine?
Yes, I did.
Did you have any license or prescription to have that in your possession?
No, I did not.
Satisfied with the factual basis, Ms. Schwartz?
Yes, Your Honor.
Satisfied with the factual basis, Mr. Rowe?
Yes, Your Honor, I am.
Has the court complied with the court rules, Ms. Schwartz?
Yes, Your Honor.
Has the court complied with the court rules, Mr. Rowe?
It has, Your Honor.
The court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. The court is convinced the plea is accurate, it has been freely, voluntarily, understandably, and knowingly made. Plea is accepted and ordered entered upon the records of this court. The motion day in August on the 27th or on the 25th? Court's gonna set 17 for the second motion day in August. I'm not sure if that's the 23rd or the 25th at this time at 10:40 a.m. or 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. So Mr. Doran, keep in contact with Mr. Rowe because we're gonna send the notice of the sentencing to him.
Okay.
So make sure you get it correct. All right, should be the August 23rd. Any questions for this person, Mr. Ween?
Mr. Doran, can you
No,
please,
sir.
Mr. Doran, can you please confirm your address?
It is 625 Eola Road. It's EOLA in Harrison, Michigan.
Mr. Doran, we're gonna be sending you some packets in the mail. You need to get those
Okay.
filled out as quickly as possible and contact the number listed on the packet, okay?
Okay, will do.
Mr. Doran, what's a good telephone number for you?
Area code 219-510-2407.
Okay, Mr. Doran, we're gonna be sending you those packets. Make sure you get them completed and make that call as soon as you get it.
Will do.
Thank you.
You're all set, Mr. Doran. You can sign off.
Okay, you guys all have a great day. Thank you very much.
On the case of the People versus Jesse Jacob.
Chief Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of the bill.
You are Jesse Jacob Hill.
You need to unmute your microphone, unmute your microphone, please.
Okay, can you hear me now?
Yep.
And, Mr. Rowe, have you received a copy of the pretrial summary?
I have, Your Honor. Your Honor, just to update the court, if the court doesn't mind. Last time we met about Mr. Hill in a formal court setting, the court instructed me to contact Ms. Ashley about having him give an evaluation. I've just in the last day or so contacted Ms. Ashley, have not received a response yet. So still in the process of trying to get an evaluation, whether he's an eligible candidate for recovery court.
So does your client wish to put in a plea today?
I believe Mr. Hill would like to take advantage of the offer if he's eligible for it, yes.
Yes, Your Honor, I take the plea today.
All right. How old are you, Mr. Hill?
31.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
So how are we proceeding on this? A little difficult to understand. What are we going to be pleading to with the prospect of recovery court?
He would be, upon successful, just one moment, Your Honor.
Is he pleading to all charges or just certain ones? With the dismissal at the end of a full probation term?
I'm sorry, you broke up, Your Honor. I'm sorry, Your Honor, I did not hear your question. You broke up. Would you mind please repeating that?
Well, the pretrial summary says if not eligible or unsuccessfully discharged, that the plea would be to count one as a habitual second. And added count 5 impaired and dismiss the remainder. But it doesn't say what he pleads to if he's being assigned to recovery court.
It should say at the end of that if defendant is successful in recovery court, then he would plead to count 2, 3, and 4, and we would be dismissing count 1 and the habitual offender 4th.
So for recovery court purposes, he's pleading to count 1 as habitual 4th?
Yes.
All right. Mr. Hill, have you received a copy of the information or gone over that information with Mr. Rowe?
Yes.
All right. And Mr. Rowe, is he waiving reading of the information for today's purposes?
Your Honor, I guess I was a little distracted for a moment when we were talking about the plea bargain offer. Is it the court's understanding that he's going to plead the counts 2, 3, and 4 today? And is this a conditional offer so that if he fails recovery?
My understanding, Mr. Rowe, is he will plead to count 1 as habitual 4th. He'll get, I'm assuming that he'll be accepted by the recovery court. He'll get appointed to it. If he successfully completes it, count 1 and habitual 4th will be dismissed, and he'll then end up with a plea that counts 2, 3, and 4, which are misdemeanors. And he'll get a benefit of not having a felony.
Okay,
but if he doesn't successfully complete, then we come back here and it's count 1 and it would get reduced to a habitual second. So he would have the felony conviction.
Okay, thank you. Thank you, Your Honor. So, Mr. Hill, do you understand that?
Yes, I do.
Thank you, Your Honor.
And so he's waiving reading of the information for today. Is that correct, Mr. Rowe?
That's correct, Your Honor.
And previously waived preliminary examination. Is that correct?
That's correct, Your Honor.
All right. Mr. Hill, you're being charged with count 1, motor vehicle, unlawful driving away. That is a felony. It carries a maximum penalty of 5 years in prison. Secretary of State will suspend your driver's license. You're also being charged as habitual offender 4th, so that makes that maximum penalty a possibility of life in prison or any term of years. The court, the minimum is discretionary with the court as to that sentence. Do you understand the charges and the possible penalties, Mr. Hill?
Yes, Your Honor.
There's one of 3 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes, Your Honor.
Answering to count 1, motor vehicle, unlawful driving away, how do you plead?
Guilty.
Answering to habitual offender 4th, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, Your Honor.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand by pleading guilty, give up each and every one of those rights.
Yes, Your Honor.
As stated on the record, Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Hill, did you hear what was put on the record as the plea agreement?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
And are you in agreement with it?
Yes, Your Honor.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No.
Has anybody promised you that if you pled guilty, this court be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead guilty?
Yes.
Now you're doing so freely and voluntarily.
Yes.
You have any questions about what the court has told you?
No.
Have you understood everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
Drawing your attention to on or about June 9th of 2021, were you driving a motor vehicle in Sheridan Township, Clare County, Michigan?
Yes, Your Honor.
And this was upon Hoover Road? And this was on Hoover Road in Clare County?
Yes, Your Honor.
All right. And did you have any permission to take that vehicle?
Well, I did, but.
All right, so this was a 2004 Dodge Ram, is that correct?
Yes, Your Honor, it was my mom.
And it belonged to another person?
Yes, it was my mother.
All right. And did you willfully and without authority take possession and or drive or take away or assist in, or was a party of taking possession of that motor vehicle?
Well, kind of, I guess, yeah.
Your Honor, if I may ask.
You may.
Mr. Hill, your mother had previously given you permission to use that vehicle, is that right?
Yeah, she
But there came
did.
a point where she told you you couldn't use it, is that right?
Yeah,
And that's when you used that vehicle, is that right?
right.
And that's this event that being talked about in the court today, is that correct?
That's correct.
Your Honor, I'm done with my questioning.
All right, and before you were driving that vehicle, had you been drinking some alcohol?
Yes, Your Honor.
All right. And what kind of alcohol and how much?
Canada House, and I had like 3 or 4 glasses, mixed drink.
All right. And did you end up, after you got stopped, taking a breathalyzer or a blood test?
Yes.
And Mr. Rowe, do you know what the results of that were?
Your Honor, I believe I do have the results. One moment, please. I know his PBT was 0.12.
Mr. Hill,
Yes, Your Honor.
was the drinking of those drinks, did that make you intoxicated?
Not to the point where I was like really unable to drive, but I was a
But
little.
would it made your blood level above the level
Oh, yes.
legally to drink?
Yes, Your Honor, it was above the level.
All right. And at the time, did you have a valid driver's license?
No, Your Honor.
And in fact, you had a conviction for driving while license suspended or revoked or denied, is that correct?
Yes, Your Honor.
And that would have been on or about July 27th of 2011 in the 80th District Court for Clare County, state of Michigan?
Yes, Your Honor.
And while you were driving this motor vehicle, did you drive it in a willful or wanton disregard for the safety of other persons or property?
That wasn't my intention, Your Honor, but yes.
It doesn't have to be your intention, but you did it in a disregard? All right. Any questions regarding that charge, reckless driving, Mr. Rowe or Ms. Schwartz? On a factual basis?
No questions, Your Honor.
All right. And Mr. Hill, were you previously convicted of home invasion in the 3rd degree on or about July 25th of 2016 in the 19th Circuit Court for Manistee County, state of Michigan?
Yeah, it was an argument between me and my ex.
Okay, you just need a yes or a no, Mr. Hill. And were you also convicted of the offense of stolen property, receiving and concealing on or about August 7th of 2012 in the 51st Circuit Court for Mason County, state of Michigan?
Yes, Your Honor.
And were you also convicted on or about July 14th of 2009 of the offense of police animal search and rescue dog injuring, harassing while committing a crime in the 51st Circuit Court for Mason County, state of Michigan?
Yes, Your Honor.
Satisfied with the factual basis, Ms. Schwartz, for all those cases?
Yes.
Or charges? Satisfied with the factual basis for all those charges, Mr. Rowe?
Yes, Your Honor.
All right. Does the court comply with the court rule, Ms. Schwartz?
Yes, Your Honor.
Does the court comply with the court rule, Mr. Rowe?
It has, Your Honor.
All right. Mr. Hill, the court took a factual basis on all the charges because if you're successful, I don't want to go through this process again of taking a factual basis for the other charges. You understand that?
Yes, Your Honor.
All right. Court has not agreed upon possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. The court is convinced the plea is accurate and has been freely, voluntarily, understandingly, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for September 27th at 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Make sure you get in touch with Ms. Ashley and get that interview done and the paperwork done before the next court date.
Okay.
All right. You understand, Mr. Rowe?
Understood.
All right. You're, any questions? No?
Mr. Hill, we're gonna bring you some packets over to the jail. We'll have you fill those out and get that.
I think Mr. Hill's out on bond, though.
Nope.
He's out on bond. Nope, that's
not him?
No, he's on the phone.
No, Mr. Hill is in the jail.
Is it? Oh, that is
Yes,
Mr.
that
Hill?
Mr.
Okay.
Hill, you're in the Clare County Jail, correct?
Yes, I'm in the job, I'm in the jail.
We'll bring over some packets for you to fill out.
Okay,
All right.
thank you.
Thank you.
You're all set, Mr. Hill.
All right, thank you, Your Honor.
Believe that takes care of all your cases, Mr. Rowe?
I believe so, Your Honor.
All right, thank you.
Have a good morning.
Your Honor, before you go on Austin, my understanding was that we were going to have a pretrial on Eager this morning.
That was supposed to be, I believe, 3:30, wasn't it?
I just knew that it was today, so,
Yeah,
that was
later
the notice.
today.
okay, thank you.
Okay.
We have Mr. Santini is on, he's logged off,
Okay,
so we don't have him anymore, but we do have Tara Hovey and James Otto in the waiting.
let's take them.
Okay.
I got confused there for a second. I was like,
I was confused,
No, and then I was like, I'm the one that let him in. I'm pretty sure I'm right.
100 I had on the phone, but that went to Mr. Doran.
Yes.
Well, in the case of the Pig versus James Junior Auto,
Chief Assistant Attorney Alicia Schwartz appearing on behalf of the people.
Tara Hovey on behalf of James Otto.
you are James Junior Auto.
Yes,
Previously, you appeared in court and pled to the charge of weapons concealed. That is a
Yes.
felony, carries a maximum penalty of 5 years in prison and or $2,500 fine, mandatory forfeiture of the weapon. The minimum is discretionary for court. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 6 months. Ms. Hovey, have you received a copy of the pre-sentence investigation report?
I have, Your Honor, and we do find it to be factually accurate.
Any objection to the scoring of the guidelines?
No, Your Honor.
Ms. Schwartz, on behalf of the people?
Your Honor, we have no additions or corrections and no objections to the scoring.
Mr. Otto, is there anything you wish to say to the court before the court passes sentence?
no, Your Honor.
Ms. Hovey, on behalf of your client?
Yes, Your Honor. Your Honor, my client and I have went over the pre-sentence investigation extensively. And with regard to that, Mr. Otto acknowledges the mistakes that he made and what he needs to do to make certain he stays in compliance with the law in the future. I believe that the recommendation of the probation department is appropriate, and we request the court to adopt it.
Ms. Schwartz, on behalf of the people?
Your Honor, we would ask that you follow the agreement in this particular case and the recommendation of the Department of Corrections.
Are there any victims present that wish to speak to the issue of sentencing? Let the record reflect there's nobody in the courtroom or on Zoom. Court has reviewed through the pre-sentence investigation report does provide for sentencing guidelines of 0 to 6 months. In order to punish you for what you've done, to attempts to rehabilitate you, deter others from committing similar acts in protection of the community, be the sentence of this court that you be placed on a delayed sentence for a period of 1 year. Along with the statutory terms of a probation, you have the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician, or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment referred by a field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service as directed by the field agent. If you successfully complete the 100 hours, the court will reduce your fines and costs by $700. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must comply with DNA testing and pay a $60 fee, pay a $68 state cost, a crime victim's assessment of $130, a $30 supervision fee. That could go up to $60 if the Department of Corrections decides to put you onto electronic monitoring supervision. You must pay court costs of $500, a fine of $500. The probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, and confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. You're not allowed to use or possess recreational marijuana. Must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. And you must set up an installment payment agreement with the Clare County Clerk's Office within 30 days for the payment of those fines and costs. If you do everything you're told, Mr. Otto, this case will get dismissed. If you don't, you'll have to come back in front of this court again. Mr. Ween, any questions or information for Mr. Otto?
Mr. Otto, what's a good telephone number for you?
989-621-3210.
Agent Nate McConnell will be giving you a call to set up your probation and stuff like that, okay?
Okay, thank you.
Thank you.
You're all set, Mr. Otto. Good luck.
Thank you.
Thank you, Judge.
Okay. Calling the case of the people versus Seneca Allen Seibert. Counsel identify for the record, please.
Thank you, Your Honor. Andrew Sanatini on behalf of Mr. Seibert.
Prosecuting attorney is Schwartz appearing on behalf of the people.
Your Honor, if I could just provide a brief update to the court.
Sure.
I talked with Mr. Seibert's attorney, Scott Moore, who's handling the criminal case. They are set to run a preliminary exam in that matter on July 22nd. Is what Mr. Moore had indicated. So I don't know how we go forward with the probation violation, I guess, at this point in time.
You wish to have this set up for about 60 days?
I think that would be appropriate, Your Honor.
You are Seneca Alan Seibert.
Yes, sir.
You heard most of that?
Yes, sir.
All right. And previously waived the right to have a hearing within 14 days. So we'll set this out about 60 days for another status conference, and maybe you'll have more information on the new charges.
Yes, sir.
All right.
Thank you.
You're all set, You're all set, Mr. Seibert.
Thank you.
I believe that's your only case for today, Mr. Santini?
It is, Your Honor. Thank you very much.
All right.
Okay. Let them in right now. It might take a minute. We did have a William logged on, but they've since hung up. I don't know.
I thought so.
This is him. Okay, so you logged on a different name.
Calling the case of the People versus William Richard Causeway. Counsel identify for the record, please.
Chief Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Attorney representing Ms. Causeway, you need to unmute, I think.
Thank you very much. I'm sorry, Your Honor. Jennifer Kuiper on behalf of Mr. Causeway.
All right. And you are Mr. Causeway?
You need to unmute your microphone, sir.
There, is that better?
That's better.
Okay, yes, Your Honor.
All right, this was just set as a status conference. Has there been any resolution of this case?
Yes, Your Honor, there has. The prosecutor has made an offer, and Mr. Causeway does wish to accept that offer.
Okay. That will be to an added count of criminal sexual conduct in the 4th degree.
Yes, sir, with no habitual offender notice and an agreement by the prosecutor to sentence within the guidelines.
All right. Mr. Causeway, how old are you?
I'm 58, Your Honor.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And Mr. Causeway, you received a copy of the amended information in this case, is that correct?
I have a copy of it, Your Honor.
Okay. And you've gone over that copy with Mr. Causeway?
I spoke in length and detail with him regarding this offer over the weekend, Your Honor.
All right. For today's purposes, is he waiving a reading of the amended information?
He will waive the reading. Your Honor, I should note for the record, it is a no contest plea, and I hope Your Honor received our offer of proof.
All right. Previously waived preliminary examination, is that correct?
Yes, sir.
Your Honor, if I may, I have not had the opportunity to review the offer of proof in this particular case. I know there's been some email exchanges going back and forth.
All the court has is a 1 page from a supplement from the Sheriff's Department. And
Yes,
so
sir.
if that appears to have a factual basis for part of it, not the date and venue.
What
What the court would want is that the court can go ahead and take the plea, but would want a written offer of proof for the file. I do not wish to have the copy of the police report in the file. Is that acceptable to both parties?
Yes, if the prosecutor can send me over whatever form they normally use, I'm happy to fill that out.
We don't have a form that's normally used. That's a pleading that's drafted. I believe we've had some email exchange this morning between Ms. Ambrositis and myself, and we talked on the phone about that offer of proof. So I'm
And
happy.
you'll draft one up and forward it to her? Is that correct?
I'm sorry, I could not hear that.
Ms. Schwartz, you'll draft up an offer of proof and forward it to the defendant's counsel?
Yes, we can do that for them.
All right. Mr. Causeway, you're charged with count 2, criminal sexual conduct in the 4th degree. That is a high court misdemeanor carrying a maximum penalty of 2 years in prison and/or a $500 fine. Mandatory HIV, STD testing, and DNA is to be taken. It is also, for purposes of the Sex Offenders Registration Act, a Tier 1 offense. If the victim is 18 years or older, it's a Tier 2 offense if the defendant has a prior conviction for a Tier 1 offense or the victim is in between the ages of 13 and 17. It becomes a Tier 3 offense if the victim was under the age of 13, the defendant was 17 years or older, or if the defendant has a prior conviction for a Tier 2 offense. You understand the charges and the possible penalties, Mr. Causeway?
Yes, Your Honor.
There's one of 4 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 4, or you may plead no contest, which means you will not contest the prosecutor's offer of proof, and it amounts to a plea of guilty. You understand the one of 4 possible pleas you may make?
Yes, Your Honor.
Answering to count 2, criminal sexual conduct in the 4th degree, how do you plead?
No contest.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes, Your Honor.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand by pleading no contest, you give up each and every one of those rights.
Yes, Your Honor.
Ms. Schwartz, would you please put the plea agreement on the record?
Plea agreement is that the defendant will be entering a no contest plea to criminal sexual conduct in the 4th degree, and we will be dismissing the remainder and the habitual offender 4th, and that the defendant will be sentenced within the guidelines.
Is that your full and complete understanding of the plea agreement?
Yes, Your Honor.
All right. First, Jennifer Weesey, is that it?
Yes, sir.
All right, and that's your full and complete understanding of the plea agreement?
It is, Your Honor. Thank you very much.
Mr. Causeway, did you hear it was put on the record as the plea agreement?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
And are you in agreement with it?
Yes, Your Honor.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead no contest?
No, Your Honor.
Has anybody threatened you or your family in order to plead no contest?
No, Your Honor.
Has anybody promised you that if you pled no contest, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead no contest?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court told you, you still wish to plead no contest?
Yes, Your Honor.
And Ms. Weezy, the reason for the no contest plea?
Potential civil liability, Your Honor.
And that's an acceptable reason for a no contest plea. And the court has read part of the police report for a factual basis is all alleged to have occurred on September 1st of 2018 in Hayes Township, Clare County, Michigan. Is that correct, Ms. Weezy?
It is, Your Honor.
Court finds factual basis for the plea. And as stated before, Ms. Schwartz, you'll make sure that it's reduced down to a written offer of proof that can be put in the file.
Yes, we'll share that with Ms. Weezy here in the next couple of days.
All right. Has the court complied with the court rules, Ms. Schwartz?
Yes, it has, Your Honor.
Has the court complied with the court rules, Ms. Weezy?
It has, Your Honor. Thank you.
Court has not agreed upon the possible plea or the possible sentence of either the prosecutor, defendant, or anyone acting in the interest of either. The court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. The plea is accepted and ordered entered upon the record of this court. Sentencing will be set for August 23rd at 11 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Case adjourned to the date time set for sentencing. Mr. Ween, do you have some questions for Mr. Causeway?
Mr. Causeway, can you please verify your address, please?
It's 4088 Valley View, Harrison, Michigan, 48625.
And your telephone number, sir.
It's 989-302-1685.
Mr. Causeway, we're going to be sending you some packets in the mail for you to fill out. As soon as you get those filled out, make sure you contact our office to schedule your PSI.
Okay.
Thank you.
Thank you.
You're all set. Thank you.
Thank you, sir.
Thank you, Your Honor. I don't know what I got to do here.
On the case of the People versus Anthony Michael Richards, might as well call up the
Prosecuting Attorney Alicia Schwartz, appearing on behalf of People.
You are Anthony Michael Richards?
Yes, sir.
You filed an application to set aside a misdemeanor marijuana conviction. Have you received a copy of People's response to the application?
I have not.
And has anybody, I don't know what the new changes, does the Attorney General's office have to be notified in this manner?
No, sir.
What we'll do is we'll get you a copy of this response. But the front of it is that you were convicted of not just the misdemeanor marijuana, you were convicted of marijuana second or subsequent offense. That makes that a high court misdemeanor, which is essentially for all intents and purposes a felony. So you may have filled out the wrong paperwork, because I think you're gonna have to fill out the paperwork for setting aside a felony conviction. A misdemeanor, because it's a high court misdemeanor. A misdemeanor under the law is anything that has 1 year or less penalty. High court misdemeanor has a 2-year penalty.
Yes, sir. But my question would be, under the new law, under the changes, the other convictions I have are eligible for this as well, and I have filed for that.
Okay.
I haven't received the prosecutor's response on that. I haven't received anything from the 80th District Court as far as that goes. So with the new law, none of my other convictions would stand, and this conviction wouldn't be a second or subsequent offense under the crime that was committed. I had.
I think what you should have done is filed this as the high court misdemeanor as a felony and filed them all at one time under one court.
I couldn't do that because it specifies that it has to be filed in separate courts.
Okay.
So I couldn't do that.
Well, as far as the way the court reads this, you know, unless you have some other things, this is not a misdemeanor conviction for under the purposes. So you either filled out the wrong form or maybe you need to fill out the right form. I don't know. I haven't looked at the forms. So if you wish, we can adjourn this and the court can do some further research. Then you could do some further research and maybe amend the application to be the felony. So I'm not sure which way to go. Yeah. This is all new. These changes are all new.
I understand that, Your Honor. I would like to, I just want to get the paperwork right. It looks like you're eligible, but I want to make sure the paperwork. The last time I was here, it was adjourned because the Attorney General hadn't responded.
Right.
Which specifically states in here that the Attorney General doesn't have to be notified.
Right.
She has nothing to do with this particular expungement. It's a separate, there's two separate forms, 227 and 227A. I followed all the directions. I would be eligible under 780.621E, sets all, says everything. I've done everything according to this. The timeline's outlined in here. I don't understand. I guess I'm not grasping what makes me ineligible.
Which statute are you looking under?
780.62E.
621E or?
Yeah, sorry, 621E. Okay. I've done everything according to this. The way I understand it, I would be eligible, especially when it says that the
problem I have is this is really not a misdemeanor conviction. Okay, so let's see. Well, it says in the statute what a misdemeanor conviction should be. And let's see if that's the statute we're working under. If you're working under the statute 333.7413 subparent 2. And
another question I have is, wouldn't the second or subsequent offense clause or status only apply if the conviction stands? If the conviction is set aside, then what is it?
That might be a logical conclusion, but I don't think the courts would rule that way.
Okay.
I mean, there's some case law regarding a collateral attack on a conviction, and that would end up being a collateral attack on a conviction, trying to set aside the previous conviction to then set aside the second conviction.
Okay.
So that, I don't think that would work. And I don't think this applies under that. I think you have to go under 780.621D, because I think this would be considered a serious misdemeanor or a felony. And I don't know, I haven't read this totally, so I don't know what the difference would be.
Would you like to maybe recess for a minute and look it over? Because I haven't looked at that section either. Just if that would be easier than rescheduling it, because
it might be a little easier. It might take a while, but yeah.
I'm in town for the day. If you want to recess for a little bit, I can stick around for the day.
That's what we'll do.
Mean
We'll take a
absolutely
short
no
recess.
offense to the court or anything. I'm just trying to get my record cleaned up. And my license is still suspended from this stuff, and again, unless I'm misunderstanding
Ms.
the law.
Schwartz, have you looked at this much at all? Other than
Your Honor, I have not. I know that I am not even sure if I received a copy of the Attorney General's response, if there was one. I'm not.
There is no response from the Attorney General's. It came from your office. I'm not, let's
I
see.
saw ours.
Do you think Michelle signed it?
Yep.
This is in the Attorney General's website. It's from the frequently asked questions.
I believe you, the Attorney General, that they're trying to make this as easy as
Expedited.
possible.
It's
I know.
expedited, yes,
Yeah,
sir.
I understand that. The problem is, I think you're working under the wrong part of the statute.
I understand
and you
that.
have to go under the other part of the statute, and I haven't read that other part totally. But I don't think it qualifies under the 621E.
Okay.
It may qualify under 621D, and then the question is, do we have to change the procedure? Do we have
And
to
go
change
through
a
the other
form? I don't know. All right, so the court will take a short recess and try and read this statute better, and we'll go from
All right, thank you, sir.
We'll try to come back. So stick around. I don't know if you got access to some of the statutes so you can read it, or the forms, so, all right. So we're in recess.
All right.
All rise. 55th Circuit Court is now in session with the Honorable Roy G. Mink presiding.
May be seated. Recalling the case of People versus Anthony Michael Richards. It's gonna take me a little bit more time to figure this out, Mr. Richards, so I'm gonna take it. It appears to me you're entitled to have it set aside, okay?
Yes, sir.
But we gotta get the paperwork right.
Okay.
And I think, after I do some more research, we may have to send you an amended application, the right one, and I'm gonna have to put it on the right order. So it's not gonna happen today,
Yes, sir.
and, we'll try and get to it as soon as possible. But it may take several weeks yet, because once we get the right paperwork in, I got to sign the order, it goes to the clerks, they have to send it to the Secretary of State. So it's not gonna get done tomorrow, it's not gonna get done this week. I don't know how long it'll take.
Well, here's my predicament. For my understanding of Section B, I wouldn't be eligible if I had to file it under that because the timeframes. I had caught some other charges and stuff. So I
you're
wouldn't
not
meet the
past the
timeframe
3 or
requirement.
5 years.
Right, I wouldn't meet the timeframe requirements.
And that may be, I don't know.
So if there's an amended application and I go forward with it, it would be denied, and then I'd have to wait 3 more years before I could reapply. So what do we do if you find,
It has to be done that way, you're gonna have to wait 3 years.
so if you find I'm not eligible, then you make the ruling that I'm not eligible, and then I just
Wait.
don't do it, right? Because I don't want to go forward with the other process,
Right.
because I know I won't be eligible. To be a waste of the court's time, to be a waste of my $50. So is that, if you find I'm not eligible,
We won't do anything. I'll
Then,
just
okay,
send an
I appreciate
order, I'll
that.
send an order and we'll send you a copy of it, and then you'll know, you'll be able to determine when you file again.
okay, I appreciate that.
Yeah, because so far I've not seen any mention of the statute of what you were convicted under being mentioned in any of this.
So, the confusion comes from the iChat record lists everything as a misdemeanor. And my other
And
question,
that's been a real problem ever since I've been an attorney. We got this stuff called high court misdemeanors.
yeah,
Which are 2-year maximum penalties. It's not a misdemeanor. And I, as an attorney, I had to tell my people that this is a felony. And if you get charged with another case, you can be a habitual offender second. And they're treated differently than a real misdemeanor.
yes, sir. And then my other thinking was that, I didn't know if that was an actual charge, or because it says enhancement, so I thought that was just an added. So if I didn't know about the lateral attack, like you mentioned.
That tends to be the conviction number.
Yes, sir.
So, yeah, that's the problem.
Okay.
Okay. All right. So, we'll try to get this resolved in a couple of weeks' time, and you should know by then.
And will I receive a copy of their,
You'll
the
get-
response? Because I
I'll
never
do
got a
it.
copy.
Oh, yeah, you can get one here before you leave here
Okay.
today. But, yeah, and then I'll do some kind of a written order telling
Okay,
you what.
thank you, sir.
All right.
Have a good day.
We're in recess.
So I get that from you or from
What are
the
you?
copy of the response?
Yeah, they filed the response and
District of Course now in session, the Honorable Roy G. Meek presiding.
May be seated. In the case of Garrett Uplager versus Ardell Uplager, come up to one of the tables. Be seated. You are Garrett Uplager.
Yes.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And do you expect the defendant to show up?
No.
There is proof of service of the complaint upon the defendant, proof of service of the default. See, we're gonna need a proof of service that you sent her a notice of today's hearing. Did you do that?
I sent her a copy via mail.
You send her a copy of today's notice of hearing?
Yes.
Okay. You're gonna need to fill out a proof of service for that, okay, for the
Okay.
file? All right. Would you raise your right hand and be sworn? Oh, already sworn, okay. Mr. Uplager, is everything that you wrote in your complaint true?
Yes.
And were you a resident of the state of Michigan at least 180 days before filing this complaint?
Yes.
And of the state of Michigan at least, or County of Clare at least 10 days?
Yes.
Stated in the complaint that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. Was that true then?
Yes.
And is it true today?
Yes.
Are you asking for any spousal support?
No.
Understand that if you're not awarded spousal support, you're forever barred from receiving spousal support. Is that a yes?
Yes.
And to the best of your knowledge, is your wife pregnant?
No, she's not.
Are there any minor children from this marriage?
No.
And you stated that there's no property to be divided?
No.
And that's because you've been separated for over 2 years?
Yes.
About 3 years now? So you have all the property personal property that you want in your possession, and she has all hers, is that correct?
Yes.
Is there any real estate owned by the parties?
No.
And you're just asking that each party be awarded whatever pension or retirement benefits they may have in their own name?
Yes.
That just each party be responsible for their own debts?
Yes.
Is there any joint debts that you know of?
No.
From the proofs that have been presented, it appears there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. A divorce shall be granted. Neither party is awarded spousal support. Each party is awarded the personal property in their possession. Parties do not own any real estate. Each party is awarded whatever retirement benefits they may have in their own name. Court is signing the judgment. The judgment is not final until it's recorded in the clerk's office. Court is signing the judgment. You can follow the clerk back to the office and she can give you a copy and then another copy to send to your ex-wife. Okay. And then we will need that proof filled out and filed today too.
Okay, I do have a question about that. I received
If you know that you mailed it, then that's fine.
okay. Oh, I did.
Why did you get notice that it was returned?
Oh, no, I was just wondering how I would go about getting the proof, because as soon as I got this.
You just sign it that you attest that you sent it to her on such a date.
Okay.
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 We're in recess.
All right.
So, we're not in recess then.
I'm all set.
In the case of Fremont Insurance versus Greenmark Equipment. Counsel identify for the record, please.
Good afternoon, Your Honor. Ashley Russet on behalf of Plaintiff Fremont.
And good afternoon, Lindsay Dangle, present on behalf of defending Greenmark Equipment.
We have a pretrial form to fill out. Are the pleadings sufficient at this point?
From our standpoint, Your Honor.
Defendant is aware of no issues, Your Honor.
All right. Exchange names and addresses of known non-expert witnesses within 28 days, later discovered, as they are discovered, but no later than 14 days before trial. Anybody expecting to call any expert witnesses?
Yes, Your Honor, we did retain 2 experts ourselves. I am not sure if defendant has or not, but.
And I.
Plaintiff to name their experts within 60 days. Defendant has 90 days. Exchange known exhibits within 28 days, later discovered as they are discovered, but no later than 14 days before trial. Court likes to receive proposed jury instructions and verdict forms at least 10 days before trial. Discovery will be left open so long as it doesn't interfere with trial. Earliest time you'll be available for case evaluation?
I would suggest January.
I could do that.
All right. If it goes to trial, about how long will it think it'll take?
2 days.
I was gonna say 3, so 2 to 3.
All right. And we'll set trial for April. All claims been joined?
Yes, Your Honor, as of this time.
Anybody want anything else in this pretrial summary?
Nothing from me, Your Honor.
Nope, that sounds good to me. Thank you.
Want to talk about anything else?
Nothing from me, Your Honor.
Nothing here either, Your Honor.
All right, thank you. We'll send you out copies of the pretrial summary. You're all set.
Thank you very
Thank
much.
you. Good to see you, Lindsay.
Same here, Ashley. Have a nice afternoon.
You too. Bye.
55th Circuit Court is now in session with the Honorable Roy G. Mink presiding.
May be seated. On the case of John Pennick versus the Secretary of State, counsel identified for the record, please.
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Todd Levitt appearing on behalf of Mr. Pernick, Your Honor.
You are John Pernick?
Yes, sir.
You may proceed, Mr. Levitt.
Thank you, Judge. Judge, this is just a brief petition seeking a hardship restricted based on an implied consent refusal. On January 23rd of 2021, my client was placed under arrest in the county of Clare, Michigan, for a potential operating while intoxicated offense under Michigan Motor Vehicle Code. At the time of the arrest, the arresting officer in charge requested that Mr. Pernick submit to a chemical test. My client refused to submit to the test, and as a result, the Department of State, the Secretary of State, suspended Mr. Pernick's driving privileges effective April 13th of 2021 through 11:59 p.m. of April 12th of 2022. Just for a little more information, tomorrow morning, Mr. Pernick is finally being arraigned in the district court right there where Your Honor sits in Clare County. And again, it's no fault of the prosecutors. It's just this case has been pending since January, end of January. So, and in that time period, my client has remained sober, by the way. My client does work part-time and would like to work full-time, but not having a driver's license. And there is no Uber, public transportation, or any form of transportation where my client lives out in Lake Michigan to get him to and from and during his employment. He works at a leather factory where I believe they make leather.
Yes, we sell leather.
They sell leather, Your Honor. So we're just asking you to consider granting restricted privileges up until April 12th of 2022, at which time, the Secretary of State would retain jurisdiction and determine moving forward after April 12th of 2022, what type of driving privileges Mr. Pernick would or would not have. And obviously, if you do grant restricted privileges based on, a hardship to that time period, any type of alcohol, any other activity under the Michigan statutes for any matter whatsoever criminally, he would have to suspend his license if it involved a motor vehicle. And then again, but for the refusal, he would be operating a motor vehicle with a 625G permit this time, Your Honor. He has no prior criminal history in regards to drinking and driving convictions. And as I mentioned, tomorrow is his arraignment, whereby the case will then start. Thank you.
Ms. Schwartz, on behalf of the people, anything?
Your Honor, we leave this within your discretion.
And Mr. Levitt, there's been no prior implied consent suspensions, is that correct?
That's correct. This is the first time in Mr. Pernick's lifetime that he refuses to submit to the test.
Court will grant a restricted license and sign an order upon presentation.
I'll do that and get that to Ms. Schwartz no later than tomorrow, Your Honor, if not today. Thank you.
All right. We're in recess.
Appreciate it. Thank you, Judge. Thank you, Ms. Schwartz.
Then I sent him out a.
What is going on?
Detail. What I needed. last few weeks.
You know? I mean, I hate to do that, but I should have left at 3. I should have left when I was like, oh, I think I should leave. I need somebody else.
See about tomorrow. Well, it was a busy day.
All rise. 55th Circuit Court is now in session with the Honorable Roy D. Mink presiding.
On the case of People versus Justin Robert Eager, counsel identified for the record.
Good afternoon, Your Honor. Chief Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Eager.
And you are Justin Robert Eager?
Yes, Your Honor.
All right. And this was set as a status conference. We've got a trial scheduled next week on July 21st. I understand the parties have been talking and this case has not been resolved. Is that correct?
That's correct, Your Honor.
All right. So, Mr. Eager, you're gonna have to appear in person for the trial. So make sure you're here.
Yes, sir.
And we'll proceed with the trial on the 21st.
Okay.
Anything else anybody want to put on the record?
Well, Your Honor, I would like to note for the record that the people have filed their witness and exhibit list and also presented to the court proposed jury instructions. I have not received the same from defense counsel, and we're now about a week away from this trial.
Court's going to order defense counsel to file any witness list of anybody that's not on prosecutor's witness list to be filed by tomorrow at 4:30. Needs to be done. Any witness that was listed without a phone number and an address will be subject to a motion to strike.
Thank you, Your Honor.
Anything else?
Your Honor, I was wondering if we could push that off to Wednesday, instead of tomorrow. Tomorrow night, it's a busy day in district court for me, both in the morning and part of the afternoon. We want to have a doctor's appointment later on that afternoon tomorrow.
I suggest you get on it tonight and get it done. And if you need to contact your client, Mr. Eager, you better provide the information that he needs to file that witness list.
Yes, sir.
We're in recess.